And welcome everybody to this panel to discuss where we stand after 30 years of the Trademarks Act 1994. All you young people in the room don't remember the 1994 Act coming into force, let alone the 1938 Act before us, but those of us who were old school remember that it was quite a big change when we got the 1994 Act. And 30 years later, well, I mean, all our anniversaries are arbitrary, aren't they? But 30 years is a good period of time to take stock of where we've got to and where we might be going forward to. And we have four very distinguished speakers this evening to talk about this. First up, we have someone who has been central to the development of UK trademark law since the coming into force of the 1994 Act, who is Geoffrey Hobbs KC, who throughout that time has been not only a leading silk at the IP bar, but has also been the senior appointed person hearing appeals from the Trademarks Registry, and therefore has been very much at the coalface of developing the law under the 1994 Act, particularly in the early years when we had no jurisprudence from the Court of Justice, and then more recently trying to interpret the jurisprudence of the Court of Justice. So, Geoffrey, over to you.
Thank you. Let me begin by saying that you may have seen that the Supreme Court posted on its website that the judgment in Sky and Skykick is coming next Wednesday. I want to make it crystal clear so that I'm not going to be sent to prison for contempt. I am not in a position to say anything at all about that case. Okay? Camera's on. Right. I haven't got very long, so I'm going to do what has sometimes been referred to in the Court of Appeal as some island hopping. Have you got the first? Oh, there we are. Look, at the threshold. So there we are, AD 2000. It literally was at the threshold in the sense that there was only one decision at that time. That was Robin Jacobs' decision in Treat, which touched questions of validity. It came to me to do the first appeal from the registry to try and explain the architecture of the legislation. The date was set for the hearing. Inauspiciously, they failed to notify the appellant that the hearing was taking place, and we had to adjourn it. We adjourned it. In between times, I got a phone call from Mr. Justice Jacob. I don't remember what. He said, "Geoffrey, hello, have you done any appeals yet as the appointed person?" I said, "Well, as it happens, I've got the first one coming up next week or the week after." He said, "Well, what is it? What's the mark?" I said, "It's AD 2000. And so with characteristic circumspection and lightness of touch, he said to me, "Bloody cheek." But as your examiners will have told you and your tutors will have told you, please give reasons for your answer. So we have the hearing. Now, what had happened? So just to give you some context, what had happened? In the registry, they'd applied to register AD 2000. This was thinking ahead to the turn of the millennium, which was going to be a huge marketing event, looking forward to it. And they'd applied to register the mark 82,000 in four classes, 29, 30, 32 and 33. All goods in classes. And the hearing officer in the registry had said, looking at that bit at the top, that he didn't think it was objectionable under para A, the para A objection, but he did think it was objectionable under the para B objection for being devoid of any distinctive character. So along comes the appeal, pretty obvious. How can I be capable of distinguishing for the purposes of para A and yet be devoid of any distinctive character for the purposes of paragraph B? And it's a fair point, and it forced me to think about what we should be doing going forward, where we got to under the 1938 Act, and how things needed to be different. Now, the position prior to the 1994 Act was actually deeply unsatisfactory. I don't want to tread on the toes of people who yearn to be returned to the 1938 Act, but it was an absolute nightmare. There'd been nearly 100 years of law in which the statute had been changed in 1919 to introduce a test for capable of distinguishing that would allow you to get a mark registered in Part B of the register. I know this is all foreign to many of you. Part B of the register, and that was, as it were, a softening provision in relation to the main test for distinctiveness, which was whether the mark was adapted to distinguish. And we'd had some really, when you look back on them, impossible to understand decisions, and I'll mention two of them. There's a case called Weldmesh in 1966, in which the Court of Appeal decided that a mark which had been already accepted in Part B and accepted that it was 100% distinctive in fact couldn't be registered in Part A because it was too descriptive to ever make the transition up from Part B to Part A. Okay. Now, that didn't stand alone. We had the York trailer. It's the York trademark case, but it's, people don't realise, I think, necessarily that that was referring to York trailers from York, Ontario. And that was the case where the House of Lords ruled explicitly that the words capable of distinguishing in the Trademarks Act 1938, Section 10, meant capable in law of distinguishing, and that 100% factual distinctiveness wasn't good enough. You try and explain that from where we are now as to how that could possibly be a basis for a rational trademark system. But anyway,
there's nothing wrong with it. I want it.
I rest my case. Right, enough of that barracking. So what did I do? Well, I worked it out. I can remember to this day where I came up with some of the phraseology. The main bit of the phraseology I used came to me while about 3 o'clock in the afternoon on a very hot day in northern Corsica, while I was sitting on a bed in a Mark Warner camp and all my family were out enjoying themselves, and I was labouring over this. But anyway, I reached the situation in which I worked out as best I could what I thought the architecture was of the A clause and the B clause and how it fitted into the grounds of objection. I came to the view that capable of distinguishing meant capable to the limited extent of being not incapable, so you can get it to the next step. And then I took the view that the B clause was about immaturity. The sign was going out, not because it was not incapable of distinguishing goods or services, but it was not distinctive, and that's where I came up with the phrase on that hotel bed. I know I borrowed it from other areas of law, other areas of learning. It wasn't distinctive by nature, and it hadn't become distinctive by nurture. That was the best I could get. It was a liberating moment for me because it enabled me to unblock my thoughts and get the decision written. So, we come out of AD 2000, and I've taken that view, and like anybody that's delivered a decision of what you think is of some significance, you sit there and you wait to see what sort of commentary it gets and what sort of feedback it gets. Right? Could you put up the next slide? So I'm going into and coming out of Phillips and Remington, okay? And it's a good way of putting it, I think, for those of us who lived through that experience. The 13th edition of Curley, which was published in 2001, came out after the order for reference had been made by the Court of Appeal in Phillips and Remington, and after AD 2000. And this is what the commentary said. I love it. I loved it at the time. Not. One advantage of this reasoning, that was my reasoning in AD 2000, is that it probably makes the best sense of the words used in section 1.1 and 3.1, and at the same time incorporates the apparent meaning of Article 3.1a of the Trademarks Directive. The reasoning also skillfully avoids touching upon any of the problems with this interpretation, which are discussed later, and there's a whole chunk later. For a time, this interpretation was generally, but perhaps not universally accepted in the United Kingdom. Hence, a sign which is capable of distinguishing in section 1.1 is to be interpreted in the limited sense of a sign which is not incapable of distinguishing. Not incapable of distinguishing. Okay, so then we get the reference to the CJEU in Phillips and Remington. What happens there? The order for reference in the Court of Appeal was framed, on the main question, was framed in terms which, for those of us who'd grown up in the 1938 Act era, was designed to find out whether capable of distinguishing in 3.1a was a tool with which you could say, yeah, never mind whether it goes out under any of the other ones, is there a role for 3.1a which says it goes out because there's some criteria, some legal criteria that can be applied to refuse it. Now, I remember reading it at the time and being puzzled by it. It's only since I've gone back to it since that I've kind of made more sense of it. The Court of Justice ruled in its judgment that the answer to that question is that there is no category of marks which is not excluded from registration by B, C, and D, which is nonetheless excluded by 3.1a on the ground that such marks are incapable of distinguishing the goods of the proprietor of the mark from those of other undertakings. All right, there were a couple of negatives, double negative in there. So, where did it leave us? I believe that to make more sense of where Phillips and Remington left us, you have to look at what I put up on screen, which is a consistency analysis. I looked at the Advocate General's opinion, which was quite terse, mainly because he thought the answer to the question was obvious and didn't dwell on it too long. You have a situation in which if a sign is not in fact capable of distinguishing, then it's devoid of any distinctive character for the B clause, fair enough. A sign which is not in fact devoid of any distinctive character is capable of distinguishing for the purposes of para A. So you kind of go in that direction, and then you kind of meet yourself coming back in the other direction. Now, the almost direct effect of that in the years after Phillips and Remington is that 3.1a became very close to obsolete in terms of a distinctiveness objection, because people worked on the assumption that you might as well just get to the end game and do the B clause, the C clause, and the D clause, ask whether there's acquired distinctiveness and all the rest of it. However, next slide, please. We are moving into an era, I believe, and this is where I'm being controversial, and Richard is likely to pick me up on this in a short while. Notice that I put a question mark on that top line there. Stricter and stronger exclusion of origin-neutral signs under para A. So let me unmask myself. I have always thought that there is only one requirement for a mark to get on the register, that is to say that it possesses by nature or by nurture a distinctive character. And I've always thought that the legislation basically set up 4 ways of failing that test, but it was basically a single test. Now, those cases, which I've mentioned there, the first one sets the scene. It's an hors d'oeuvre for the second one, which is Neopearl. Neopearl is a case about a tactile position mark, and it's one of those cases which has got the rare thing, which is permission to go on further appeal to the Court of Justice. And basically what the General Court said and what the Advocate General has endorsed in his opinion in September, only a short while ago, is that in the architecture of the legislation, so on a systematic structural interpretation, you must ask whether something clears the A hurdle before you go on to question and examine whether it's passed the B, the C, and the D hurdles. Fair enough. Now, I believe that we are at the point where we could, so I'm looking forward as opposed to looking back now, I believe we're at the point where we could see jurisprudence in which the A objection gets more traction than it's had before, and that we can have stricter and stronger exclusion of origin neutral signs. Why do I say that? I say that because if it's origin neutral, it isn't going to pass any test for distinctiveness that you can think of. Using that as a rule of thumb does not say anything which clashes with the consistency of interpretation rule. in Phillips and Remington, and it has one great advantage. It means that if you say that something, if you examine and you find that something is out under A because it's origin neutral, you don't create this bear trap which arises for economic operators later down the line on infringement cases to fight their way successfully through concepts of minimum distinctiveness, weak distinctive character, interference with protected functions. All of those things they shouldn't be subjected to. So to adopt some of the terminology from the Old English cases, which does run forward, honest traders shouldn't be forced to look for defences on marks which shouldn't be on the register in the first place. Now, the argument with which I'm very familiar that comes back the other way is, but the A clause is dealing with abstract questions of distinctiveness, whereas the B clause and its satellites is dealing with the in concreto, the concrete case. And I've heard that argument many times. Not only have I heard it many times, it's stated by the Court of Justice in the Postcantor case that it's you're only asking whether the sign, for the purposes of the A objection, whether the sign is capable of being a trademark for anything. And you know what? I've come to the conclusion that that's just completely wrong. And it's time that this was looked at. Why do I say that? The relevant legislative provisions on this are now Article 59, brackets 3 of the EU TMR and Article 7 of the Trademark Directive. Those are the legislative provisions which require you to assess any mark for registrability with reference to the goods or services which are specified in the application for registration or the registration. They and their predecessors always did, and those legislative provisions apply to the A objection no less than to the B objection. From my perspective, there is nothing wrong in doing an A objection for origin neutrality or an A assessment and doing it with reference to the goods and services. And I frankly think, looking back on it, that the emperor was not wearing any clothes, and it's nonsense to talk about just whether something is capable of constituting a trademark for anything at all. I think it's wrong, but that will be controversial, I suspect. Right, let me move to the next slide, clarity and precision. Let me tell you a story. I went to one of those meetings. Have I run out of time? No? I went to one of those meetings in the...
Nearly out of time.
Nearly out of time. Life is so short, Richard.
But go on.
Go on, all right. Since you begged me, I will. Clarity and precision. Okay, how did it all start? I was in one of those meetings. They used to have them quite regularly in what was called the Combaldio room at the EU IPO. It's one of those classic EU institution meeting rooms with horseshoe-shaped tables and inner horseshoes and some vertical facing tables in the middle and so on and so forth. And I was listening, and for easily 2 hours there were protests from all of the judges who were, well, all the ones who were speaking anyway, about the practice statement, communication number 4 of 2003, June 2003. That's the use of class headings. As you, I'm sure you know, this is the theory of treating the class heading wording as a code. So that if you use all the class heading at the date of your filing, you are deemed or taken, don't care really how you put it, to have covered everything subtended by those words in that class. And then, just for good measure, if you choose only one of the items in the class heading, or 2 of the items, you are taken to have subtended everything which is under, claimed for everything which is under that particular part. Now that's an exercise in itself, by the way, to work out what is and isn't subtended. And the judges in that room were pretty fed up. And one of them, as I was walking out, we got to the end of the meeting, and a senior official at the EU IPO, who I shall not name, said, well, we've listened very carefully to the submissions that you've all made here today, and we will examine them, and then ended with the chilling words, but we won't change our practice. Okay? So there you go. And as I came out, a judge, I think was from the Netherlands, he said, this is terrible, we've got to do something. And that was when, inwardly, in my heart of hearts, I resolved that if there should come close to me an opportunity to make a reference to the CJEU on this point, then I would take it, which I did. Now, the Chartered Institute of Patent Agents did a really good job of framing a specification for an application which exquisitely raised the issue. I duly made the order for reference. But it wasn't duly. I mean, I did it. I thought about it. I wrote a proper reasoned reference. I didn't just send it off. I happened to be in Alicante for one of the appointed persons meetings the day before, the evening before, this reference that I had made was going to be heard in the Court of Justice the following day. Grand Chamber, I think. And they all said, oh, Geoffrey, sorry, don't want to upset you, but we're going to go there and say that it's they shouldn't listen to the reference, it's hypothetical, it's abstract, it's contrived, it's whatever, okay? Fortunately, I'd thought of that to the extent of making it crystal clear that I was deciding the case on the instant application for registration, which was a real live application made by a real live applicant who had paid the application fee. And I thought, and as it turns out, I'm glad I was right, I thought that'll be enough to make them concentrate on it, which they duly did. And then they gave their judgment, and most of you here are familiar with this and familiar with the repercussions that came down cascading through the legislation and practice and the case law afterwards. All a bit of a mess, but now consider this. They said, yes, you have to have clarity and precision. They gave some ways of approaching that question. And then this. Did it make any difference at all? Because any of you who've got filings in the EU IPO will know that under the EUTM regulation, it says in the relevant article, which momentarily escapes me because they moved it, I think it was Article 28, it may now be Article 33, but don't quote me. It says you can use general terms. And every case, because it's one of those things that you watch down over time, every case where it comes up, they're content to use general terms. And by using the general terms or allowing an application for revocation to succeed, but keeping the registration in place for general terms, they haven't done a lot to actually implement what many would, well, Richard, I think in particular, but many would hope had been an attainable objective on the ruling of the Grand Chamber in the master case. So, yes, we got them to concentrate, but it hasn't really made a lot of difference. But you all have practical experience of filings and contesting and relative rights cases. You can tell me. Now let's throw up the last slide. Am I done?
Yeah, I think
okay,
we ought to
I'm
move
done.
on.
Any questions you want to ask me about the trade and cooperation agreement and those last two bits there, where the Supreme Court says that courts and tribunals should not have regard to what's been said by the Court of Appeal in this case, can ask me later. Right.
Look forward to a half an hour discussion on that. Right.
Okay, thank you.
I think we have to move on to our next speaker. And our next speaker is Kelly Salinger, who is President of the Chartered Institute of Trademark Attorneys and chairs its Education, Qualifications and Standards Committee, and she is a partner within CMS's Intellectual Property Department, and among other things has contributed to the Trademarks Handbook published by Sweet and Maxwell. So over to you, Kelly.
Thank you, and can we hear me okay? I'm not sure I've quite mastered this. So I've got the hard act of following Geoffrey, which I really appreciate whoever did the lineup, so thank you for that. My job today is to play slightly at devil's advocate, so I've got 5 minutes to address you. And in 1994, when the Act came in, I was 10. So I don't pretend to have all the answers or the experience of those in the room, but I'm hoping to be in the profession a bit longer. So hopefully what we can address today is where it might go and how it might change. So I'm not going to talk about a case from when I was 10, but rather than when I was in my mid-20s and at the beginning of my career, And I was still very much trying to understand that reputation 3-limb test, where you're pleading under section 5.3 and 10.3. And I've given myself the rather difficult job of summarising in 10 minutes an example of how what I thought at the time was a rather exciting CJEU decision might have turned into something of a Schrodinger's cat. And then I'm going to talk through how it progressed and touch on the tricky topical subject of copycats and lookalikes. And so to L'Oréal and Boulogne. I know this case is divisive. We have people on the panel who have attempted to apply it. We have people in the room who have no doubt opined on it and will no doubt have views of their own that they're able to share later in the session. But the question referred that I want to touch on, which is about the copycat lookalike application, was the question on unfair advantage. So most people in the room will know it was a case that was referred up by the Court of Appeal in 2007, answers handed down in 2009, and the UK case issued in 2010 on smeller-like perfumes and comparative advertising. And the question on unfair advantage was, can that take place without showing detriment to the distinctive character or reputation? And yes, says the ECJ, so yes, we can move on. And I think it was around that time that the profession really started to think about the different functions of the trademark. So for a long time, we'd had this essential origin function. And now we were presented with these answers where they say we can look more at communication and investment and advertising. And it's been 15 years since that decision. And I think it's fair to say that we haven't seen the amount of case law as we might expect to come from that decision, in no small part because I think people are still struggling to apply it. So we've obviously had lots of cases that deal with copying. We had the penguin puffin case. We had Moroccan oil and miracle oil, although I'm not sure I'm applying anything to myself called miracle oil. The Charlotte Tilbury case. And then the more recent cases of Thatcher's and the gin bottles. And I'm going to touch a little bit more on Thatcher's. So we don't have consistency in terms of how these cases are addressed. We've got the patchwork of passing off copyright and design law. But I think often when we as practitioners come across these cases, we are looking to L'Oréal to see whether we can shoehorn or find a way of properly addressing that unfair advantage point. And so because you can't paraphrase Daniel Alexander, I'm going to repeat him word for word, and his particular decision in Planet Art. Don't cover your face, it's fine, I've taken a good bit. So the difficulty with this aspect of law is not conceptual. It's hard, and I think we can all agree it's hard, because you have to disentangle a defendant's intention to copy from the intention to benefit. And that sort of links all of these undue unfair advantage cases together. So any rival trader who is adopting similarities in the approach is intending to benefit. But are they intending to benefit from the reputation and the goodwill? And I think that's what we're still really struggling with, both in the courts and as practitioners, to apply to our cases. We've had a bit more guidance on it. We've had Sky Kick that says, again, we've got this sufficient if the objective effect of the use complained of is enough to enable the defendant to benefit. And some more commentary from Planet Art, where we talk about caution being needed when we're making this assessment, since it's rarely admitted by key witnesses, and it's usually concealed. So then on to Thatcher's. We've probably all looked at it, tried to apply it, read it many times. And in that case, we know they were trying to find a benefit from the reputation and marketing efforts that had been made by Thatcher's to promote their own product. And no, said the court, there's no unfair advantage here. I mean, the set of facts are very complex, there's other bits, but for the purpose of this small section tonight, no unfair advantage. I'm not satisfied the intention to exploit the reputation and goodwill of the trademark, or that use of the sign has objectively had the effect of doing so. So in fact, Thatcher's, we had evidence before the court of benchmarking. The director or the CEO of Audi openly admits that Thatcher's was used as their benchmark. And whilst they were quite careful in disclosure, there were no written records of what actually happened in these marketing meetings. They say most things happened over the phone. Clever Audi. they did admit to the court that, for benchmarking purposes and comparison purposes, Thatcher's was a good base mark for their product. So if we take Planet Art and we're saying it's normally concealed where we're looking for this unfair advantage, if they're confessing it up, is that saying there isn't an unfair advantage? But that doesn't feel quite right either. It doesn't feel like it quite fits. And I certainly don't have all of the answers on this subject, but it feels like we're making unfair advantage incredibly hard. Like we're moving to a position where we're assessing some kind of deceptive practice as unfair advantage, almost an assessment of fraud, and that feels like a very high benchmark indeed. So I suspect others on the panel will have a view on this, but what I'm wondering is if we're just making it too complicated and whether we just need to give it a bit more time. So as practitioners, we are very used to now assessing the likelihood of confusion. There's lots of body of case law about that, and we could probably all take a pretty good view on whether trademarks are similar and do so every day in our practice. And it might be with some more case law around this subject that actually unfair advantage becomes a bit easier to spot. And maybe it's one of those cases of, when you see it, we just haven't had the perfect combination of facts yet. Or I guess the other question is whether we need new legislative provision to deal with it. So the British Brands Group, as many of you know, will have a paper on parasitic copying. You can view it on their website if this area is of interest to you. And they're very much petitioning the UK IPO and UK government for something akin to unfair competition in Europe. And I guess our last chance is the Thatcher's case on appeal. So coming to a court near you just before Christmas, I think it's floating at the moment on the 17th and 18th of December. So again, if it's of interest, maybe get down to the court before Christmas. And it might be that gives us some more answers on this space. But I think what I'll leave you with is 2025, so 15 years on from L'Oreal, we're still finding our way with this particular subject. And I think it's just going to take a little bit more time to play out.
Thank you, Kelly, for that very succinct contribution. For those of you who don't know, most hearings in the Court of Appeal these days are live streamed in the same way as Supreme Court hearings are. Not 100%, but most. And so there is a strong probability that those of you who are interested in the Thatcher's case will be able to watch it remotely from your workstations, wherever you may happen to be, and you don't have to come down to the Royal Courts of Justice in Strand to watch it. Right, our next speaker is Robert Burrell, who is Professor of Intellectual Property and Information Technology Law at the University of Oxford, where he served as Director of the Oxford Intellectual Property Research Centre from 2023 to 2024. He's also a visiting professor at Melbourne Law School, and he's written extensively on trademark law, and among other publications is a co-author of Australian trademark law, the second edition of which was published in 2016, and that provides, I hope, a good cue for the subject matter of Robert's reflections this evening.
Thank you very much, Richard. And thank you to the organisers. So the organisers made it clear that we should have some sort of personal reflection, and that got me thinking about my own sort of the things I could talk about. I could talk about Lionel teaching me about the about to be implemented 1994 Act. So that would just to remind everyone in the room that Lionel's much older than I am. But I actually thought where I'd actually start was. So I arrived in Australia in 2002, and at that time it really felt as though UK and European trademark law was still really sort of exciting and dynamic, and it was still really being looked at in large swathes of the world as the gold standard. So New Zealand's 2002 Act, which is very heavily modelled on the 1994 Act, was about to come into force. If you looked at the Australian manual, there was an extensive section on British sugar and how that was helpful in determining when goods are of the same description, to use the the Australian language. But by the time Michael Handler and I came to write the first edition of Australian trademark law in 2010, I think it was pretty clear that the influence of UK law was beginning to wane, and was beginning to wane really quite quickly on both sides of the Tasman. And I think it might just be interesting with Brexit now to reflect on why that occurred and what might happen going forward. And I suppose in biographical terms, you can think of it like this. The UK Trademarks Act, well, at 7 or 8, he was still quite cute. The relatives still liked him around. But by the time he was 15 or 16, he'd really begun to go off the rails, started experimenting with free riding. And really, from that point on, I think the influence, and I think just to show this isn't just me, David Llewellyn, writing in the context of Singaporean law in 2013, Singapore courts have shown themselves willing to chart a course different to that of many courts in Europe. Over recent years in Europe, practically any opinion in favour of more rights and more protection would have been vindicated by some judgment or another. The same is patently not true in Singapore. Andrew Brown, earlier this year, the New Zealand barrister, the pragmatic approach is to consider whether it is or is not appropriate to follow the reasoning of the United Kingdom and, in particular, European Union decisions. And I think you can just see that sort of change. And so what's caused this loss of influence? Well, some of it, I think, is just inevitable as attention has fallen on local drafting issues, conscious policy decisions. The retention of use as a trademark, for example, as a precondition for infringement in both Australia and New Zealand. After the CITMA decision, I think attention began to be focused on the fact that the Australian equivalent, the Australian sort of equivalent, its graphic representation requirement was clearly not intended to have the same sort of effect that we saw being attributed to graphic representation in CITMA. There are other doctrinal differences that I think people sometimes forget. The recitals really are an important aid to interpretation, and yet none of the jurisdictions that followed, I think this is true, certainly neither Singapore nor New Zealand sort of implemented the recitals as well. But there are also differences in mindset. I remember looking at Curley, and I think it may still say this, that the 1994 Act was meant to be a more or less complete break with the past. That was simply not necessarily how legislation like the 2002 Act in New Zealand or certainly the 95 Act in Australia was understood. And so I think some of that is perhaps just inevitable. But then I think we get to the things where we see, I think, if we're being honest, a more malign influence of the European Court of Justice in terms of how Court of Justice decisions were received in other common law jurisdictions. So, of course, we've got differences in the mode and style of judicial reasoning coming out of the Court of Justice. I think, CJEU cases just simply do not land as well with common lawyers as we came to have to accept them and sometimes love them. But, in other Commonwealth jurisdictions, I just don't think they ever landed in quite the same way. We've also got, very different approaches to legislative interpretation. What Lionel's described as, the policy-driven rewriting of the legislation. The Court of Justice is prepared to say that the words "are not similar" include similar. That's just never going to happen. A New Zealand court or an Australian court is simply never going to be prepared to take that leap of, or whatever we want to call it, leap of logic for policy-based reasons. Similarly, if you look at why is it that, and Geoffrey probably quite likes where Singapore and New Zealand have ended up, but keeping capable of distinguishing as some kind of threshold requirement. Well, that seems to follow quite naturally. If you start with, Ditcher and Denison, the 1850s rule that, a presumption against legislative redundancy, and you say, well, the legislature has used two different words in two different sections, it must have meant two different things. And the idea that you just would be prepared to gloss over that for some policy-based reason just just doesn't land as well in other bits of the Commonwealth, I don't think. And then, of course, we get to the real fun bits of the Court of Justice, the swings and uncertainty in Court of Justice case law. You can imagine, being on the other side of the planet watching Baby Dry and then Double Mint, and at some point thinking, I don't think these people know what they're doing. I think we should just probably chart our own course here. Paul Sumter writing about trademarks in New Zealand. He's talking about how Section 18.1 of the New Zealand Act, the equivalent to Section 3.1 of the 1994 Act, should be interpreted. The United Kingdom cases should be treated with caution because of the influence of European law and the fact that the decisions of the CJEU may not be producing a body of law that is always coherent, to put it mildly. We've also, of course, had decisions that appear surprising or unorthodox, or I would usually say wrong, but I think they particularly appear surprising and unorthodox when you think about sort of the fact that in other jurisdictions you simply don't have some of the pressures which we could perhaps, from which we can perhaps understand what the Court of Justice is doing. So Mitsubishi and Duma, for example, struck me as a pretty extraordinary case. Many people will know that I was not a huge fan of L'Oreal and Balleur when it was handed down. But of course, what we can say in the Court of Justice's defence is that the Court of Justice is probably embarked on a campaign to try and reduce the impact of national differences in unfair competition law through the trademark system. Well, as soon as you set that concern aside, you shouldn't be surprised if courts in Singapore or New Zealand, not facing that same dynamic, just treat those cases as obviously wrongly decided. Now, what about going forward? Well, I think first of all we should recognise that divergence, I think, has come at a bit of a cost. And just starting with the cost that I see from Australia, we now have a decision of the full federal court in the energy beverages case, I think Richard would like, but telling us that the NIS classification is always irrelevant to determining the scope of protection. Now, whatever we think about that case as a policy matter, I think it's really surprising that we're now at the stage where an Australian court will hand that sort of decision down without anyone citing any of variously Technic, Pathway IP, multi-access, etc., etc. That strikes me as surprising and something that we wouldn't have seen back in 2002. I think it's inconceivable, actually. And so, of course, the question is, after Brexit, are there opportunities for reconvergence? Do we even care? Is that something that we should... Is this a UK PLC question? Do we care about the influence of UK law in Singapore and Australia, or is that not something we're concerned about? And it seemed to me that there is possibly scope for reconvergence. UK courts going forward will be handing down judgments that I think are more readily accessible and more likely to be accepted by courts elsewhere in the Commonwealth. But I suppose one question for the people in this room is, to what extent, when cases are litigated going forward, are people going to be looking beyond, say, the General Court or beyond the Court of Justice for cases of persuasive authority? Are people going to start litigating cases where they say, well, actually, exactly this question has been considered by a court in New Zealand or by a court in Singapore, and there are now no shortage of examples where we see Singapore courts going in a different direction. So if you look, for example, at Singapore's shape exclusions, they are still shape-only exclusions. The Singapore Court of Appeal has said it is possible to mosaic between the different exclusions in a way that we've been told by the Court of Justice is not permissible. So it's things like that. When that case comes for reconsideration in the UK, are we going to be, are we as practitioners going to be looking at those other jurisdictions, or are we going to try and remain much more squarely within the European fold? Thank you very much.
Thank you, Robert. Well, I had no idea that Robert was going to mention the Technic case, but since he has, I can't resist contributing to the flow of reminiscence that you're getting this evening. So, for those of you who are too young to remember, this was a case involving a classic opposition battle in the registry. And it turned on how goods should be classified, and in particular whether the scope of protection was influenced by the class. And there was a decision in the registry, there was an appeal, which was heard by Hugh Laddie, Mr. Justice Laddie, and he allowed the appeal and gave a very carefully reasoned judgment. And then there was then an appeal to the Court of Appeal, presided over by Lord Justice Mummery, who also knew a lot about trademarks, and they allowed the appeal and gave a carefully reasoned judgment. And at that point, yours truly was instructed by the party which had lost in the Court of Appeal, saying, we want to take this to the House of Lords. I mean, it's quite extraordinary when you think about it, that, you know, they wanted to go for a fourth instance, but they did. And so in those days, the procedure was you put in a written petition for leave to go to the House of Lords. And sometimes you would be given the permission on paper. Mostly it would be refused on paper. But if the House of Lords was in doubt, in those days they would give you an oral hearing. So we had an oral hearing of the petition. So I was grilled by 3 law lords for 30 minutes. It was the most intense piece of advocacy I ever had at the bar. And at the end of it, they said, we'll give you permission. Great. So we get permission to go forward with our appeal. And in the usual way, we prepare printed cases and we get ready. And the case is listed for hearing. And it's going to start on a Monday. And Friday afternoon, before the Monday it's going to start, I get a phone call. The parties have settled. Such is litigation, and such is the life of the barrister. So yes, well, the alternative perspective, of course, is that Hugh Laddie was right, but there we go. So we are now going to get another perspective, and I'm very pleased to introduce our last speaker this evening, Professor Annette Kakur, who has held numerous senior research roles at the Max Planck Institute for Innovation and Competition Law in Munich since 1980, although she's now formally retired, I believe. She's also an adjunct professor at the University of Stockholm and has held visiting roles at other institutions. Among many other wonderful publications, she is the co-author with Martin Senftleben of European Trademark Law, a commentary published by OUP in 2017. And if there's anybody in the room who doesn't have it on their shelves, you ought to. So, Annette, over to you.
Thank you for that kind of advertisement. So thank you very much for the organizers also to invite me. So my role as the last speaker is to give you a perspective from the outside, that is from the EU. We still regret, at least I still regret, that this is over. Our community is over. We are now separated. And I want to ask now, in this context of celebrating 30 years of the Trademarks Act, which was, of course, an implementation of the Trademark Directive. So what lies ahead for us who remain behind? So let me first remind you of some basics. Of course, trademark law, trademark rights are IP rights. At least we have come to consider them as IP rights, although they have certain structural elements which are different from other IP rights, such as copyright and patents and so on, but I don't want to dwell on that. They are IP rights, okay, but it's extremely important, in my view, that the conditions and scope of trademark protection are shaped by the role of trademarks to enable and maintain undistorted competition. That is really the basic tenet, and that should be kept in mind, not just as a remote principle on which trademark law is originally built up, and then we can forget about it, but it is something that we need to keep in mind whenever trademark law is applied in practice. At least, again, that is my conviction. If we forget these principles in the interpretation of legal rules, then decisions tend to be flawed. And now I come to my point. One could always be sure that UK courts and scholarship would be active, would wave the red flag, would sound the alarm when things like that happened. So whenever things went wrong, when the basic tenets of trademark law were not sufficiently taken into account, they would protest. And that was a kind of corrective that we may be missing now. Now, I don't want to sound like I'm fishing or that these are is a cheap flattery to those who have invited me to this evening. I'm really serious about this, and I also have to say that I don't have not always and still don't always consent with the kind of criticism that was raised here. For instance, it's true that one can very easily agree that the L'Oréal v. Belleux decision was a bad one. And I mean both in the part about extended protection and also in the part about, well, maybe we don't agree on the part on extended protection, but I think most will also agree that the Court of Justice simply did not go into the depth of the case concerning whether the taking of advantage, which definitely occurred, was indeed unfair and whether it was without due cause. And it was also a bad case concerning the double identity part, where they came up for the first time with their functions theory. But once it became clear how the functions theory could be contained in practice, how it could be applied in practice, then I think the criticism that was voiced was sometimes a little bit exaggerated. Okay, so again, I don't mean to give you credit for everything that came out of the UK in terms of scholarship and decisions, but it's definitely something where it was, or at least for myself, it was always enjoyable to read the decisions and to read the articles, because they not only was there this spirit of sound skepticism and criticism, but there was also this, to take up something that Daniel Alexander said this afternoon, this level of granularity, so this level of in-depth argumentation that you could find in these decisions was always extremely valuable, I think. Again, and we could be missing that. Here is a slide missing, because I wanted to tell you about one specific case, and that starts here. So the slides are a little bit out of order, but let me start here. So I want to tell you about the case of Audi v. GQ, because I fear that might be one sort of cases that we might see more often in the future without the corrective that UK scholarship and jurisprudence have provided to us. So this was a question coming up from Poland about somebody who imported and marketed a radiator grill that had a device on it. You can see it on the photo. It's not a very good photo, but you can probably know what it's about. It had a device which allowed affixing the Audi logo with the 4 interlocking rings. And I have to add that Audi themselves, they did not, this is for very old Audis that are still running in Poland, but are not very much on the street in other European countries, for instance, in Germany. And Audi themselves, they did not even sell this radiator grill in Poland. So, but Audi filed suit, and in Poland, and the Polish court referred the questions to the Court of Justice, which, in a summary, are whether the selling of the articles fell within the limitations in Article 14, first paragraph, subparagraph C, which is used to indicate purpose, and if that would be the case, whether it was compatible with honest practices. And then as a second question, although logically, of course, it would have been the first question, whether it was infringing in the meaning of Article 9 of the EU TMR. And now comes the Advocate General opinion. Advocate General Medina denied that there was an infringement, because she said the device has a functional character. It's indispensable to use such a form if it shall function as a replacement part for these old Audi cars. So she concluded it is excluded from trademark protection, which is a little bit bizarre because this was not about the protection as a mark in the sense of the sign being eligible for trademark registration, but it was about an infringement. But what she meant was, I would say, that the device was not used as a mark in the situation. And she was also pointing in that context to an academic study that had been conducted years ago. It was an independent academic study. It had nothing to do with the case litigated in court. That was conducted by a psychologist and a law professor. And it was shown in that study that if professional customers, dealers, and those were the only ones that were addressed or were targeted by the offers made by the importer, they were not subject to likelihood of confusion. And then she also said that, of course, she is aware that it is not possible to apply the spare parts a limitation, the repair clause that operates in design law by way of analogy in a trademark law. But she says, of course, that one has to keep this, the possibility to offer spare parts under design aspects in the course of trade, because she says it complies with a consistent and practicable interpretation of all areas of intellectual property law to keep in mind these limitations in order to ensure that the emergence of monopolies is prevented and that the interest of consumers in being able to obtain goods and services from many different sources is protected. So that was the Advocate General. Now comes the so I wanted to highlight this, but yeah. Now comes the answer of the Court of Justice, and the Court of Justice said, first of all, talking about infringement, the relevant articles must be interpreted as meaning that the third party who, without the consent of the manufacturer of motor vehicles, which is a proprietor of an EU trademark, offers and imports and offers for sales these parts containing an element which is designed for the attachment of the emblem representing that trademark, is using a sign in the course of trade in a manner liable to affect one or more of the functions of that trademark, which is a matter for the national court to ascertain. And concerning the limitations, they said that they are simply not applicable because this limitation that allows reference to a sign to indicate purpose must be interpreted as meaning that it does not preclude the manufacturer of vehicles from prohibiting a third party from using the sign where that sign consists of the shape of an element of the radiator grille. So the Court of Justice was quite adamant, was quite clear. First of all, there is liability of the use of the mark to violate the functions, and the limitations are not applicable. So my comment is, I completely agree with the Court of Justice that the Advocate General's opinion could not be followed insofar as she seemed to assume that this is a question of whether the part could ever become a trademark. That was simply not the question which was at stake here. The Court of Justice was also right in holding that the repair clause from design law cannot be applied by analogy in trademark law. It's clear that is something that has already been decided by the court in the Ford case. But this does not explain why the Court of Justice remained completely silent about the study which had been addressed by the Advocate General, which showed that there was no likelihood of confusion at all among professional customers, and those, again, were the only customers that those parts were sold to. It's also not explicable why the Court of Justice discarded any consideration of the legitimacy and desirability of competition on the aftermarket as an undue attempt to apply the repairs clause by analogy. Again, this was not the question here. Of course, there is no application by analogy. But what the Advocate General wanted to do, and what she said, is that in the interest of the consistency of the law in its entirety, the policy arguments that have induced the European legislature to introduce the repairs clause into the design law, they cannot simply be discarded as irrelevant when we are talking about the application of trademark law. So that is something which is really showing that the Court of Justice is applying a kind of compartmentalized view here. They don't see the entirety of the competition environment that trademark law applies in, and that shall be fostered by trademark law. And it's also cannot be explained why the application of Article 14 should be excluded. In the material which you will find on the website, I have added a short commentary by myself to the Audi judgment where I expand a little bit on that one. So my question is this decision and the kind of lack of the overall view here a bad omen for the future? Does it really indicate an area of rigid and proprietor-centered interpretation of EU trademark law, which is unable or unwilling to recognize the inherent limitations that result from trademarks being a part of a larger system geared towards efficient competition and other policy goals? That's my question. We'll see about that, but what I can tell you here this evening is that at least for the actual case, the Polish case that went back to the court in Warsaw, the end appears to be a happy one for the Polish dealer, because a friend of mine informed me just today, around lunchtime, that the court in Warsaw has handed down its decisions in its decision in this case, and they found that there is no infringement. They found that neither the origin function nor any of the other functions was jeopardized. So in spite of the wording of the Court of Justice that seemed to suggest that the National Court, of course, had its own space of appreciation, but they were in the end supposed to find that there was an infringement of the functions. The court in Poland was bold enough to realize that they had a room for their own decision, and they found, based on the facts of this case, that there was no infringement at all.
That's brilliant.
Thank you. So just if I can exercise Chair's prerogative of asking the first question, I'm going to direct it to Anessa, because what you've just told us seems to me to be a perfect illustration of the points you made earlier in your talk, namely that the concern that many people had post L'Oréal and Boulogne as to the functions theory was perhaps a little overplaced, because what the functions theory does, if it's properly utilised and applied, is to give flexibility to national courts to reach sensible decisions on the facts.
You made my point, so I don't have to add anything. Thank you very much, yes.
All right. Very good. So we do have time for questions from the audience. So I'm hoping we've got a microphone. And the point about that is that, of course, this is a small enough room that those in the room can probably hear without the microphone. But please think about our audience online who can't hear you if you don't have a microphone. So,
Thank you.
Alexander von Mühlendorf.
Thank you, Chair. I have a question to Jeffrey, if I may, because you were talking about the marks which are origin neutral.
Yeah.
And I don't think that the Neopal case is a good example, because that may have origin function, but it was a taste mark. So it doesn't really follow from what you were saying. Do you have some good examples of origin neutral marks that you would consider not to be registrable regardless of any goods or services?
Not off the top of my head, but if I had a little bit longer I could find some. But I just want to make a point. It's the mark that was in issue in the Neopal case was a tactile position mark. And what the General Court had done was to raise what you'd call an ex officio objection to the legality of the application for registration for the first time in the General Court. And they did it on the basis of a systematic interpretation which says you must look at the A clause before you go to the B, the C and the D clause. And their reasoning, I thought, was quite convincing. They followed themselves in an earlier decision on that. And the Advocate General has also found that reasoning convincing. My point is not that that was, in that particular case, a mark which was origin neutral. My point is that the same logic should apply not just to the graphic representation part of the definition of a trademark, it should also apply to the capable of distinguishing. I then go to the next point, which is, to me, it stands to reason. If something is origin neutral, as opposed to origin specific, that is what I think the antithesis is, it shouldn't go any further. And you should be able to say that at the A clause stage. And if you want to go on and say, I combine the A clause and the B clause for that purpose, that's fine. But the issue that I encounter when I put forward this view is the jurisprudence, which you'll find, obviously I mentioned it in post-cantur, which is the idea that you're really only considering the capability of assigning in abstracto under A, and it's in concreto under B, and I simply don't accept that. To me, the legislation gives you the opportunity, even if it doesn't create the obligation, brackets, I think it does create the obligation, but it gives you the opportunity to conduct an examination by reference to the specifically listed goods and services. So that's a long way of answering you, but my view is if a sign is in fact origin neutral, that should be the end of it.
Yeah, I mean the alternative.
No example.
Well,
It's self-evident.
let me give you an example which you can debate the effect of it. But the example I would give is the Dyson case in the Court of Justice, which again was another reference from this jurisdiction, where what the Court of Justice said was that that did not comply with the A clause because what was being claimed was incapable of distinguishing in relation to any goods, not because of an absence of graphical representation, but what was being claimed was essentially an idea, because it was the idea of a clear, transparent bin on a vacuum cleaner, regardless essentially of shape or anything else. And they said, well, that plainly falls foul of the A clause. And one perspective on that is that that demonstrates that the A clause does have utility, because that's an example of its application regardless of the particular goods or services. And if the problem with the alternative view, it seems to me, is that it's then impossible to differentiate between application of A and application of B. So the argument from redundancy of legislation would suggest to you that you shouldn't give them precisely the same effect. But that's not to say that there may not be cases where the A clause should be applied a little more vigorously than perhaps it currently is.
Well, concerning this argument of redundancy, you might say that the A clause, at least, so if it's interpreted in the manner which I also interpret it, I have to say, I understand it as being very abstract, as just being about is this sign capable of distinguishing at all, no matter what the product is, no matter what the situation is. And I think that Dyson is a bit of an atypical case. They could also have solved it in a different manner. Otherwise, I'm really at loss. I don't know of many cases that fall under A. but you can still say it makes sense because it is not really a threshold. It's an opening clause. It's an opening clause that tells you, so A, which refers, of course, to the definition of science that are eligible for registration, tells you that you should not exclude anything under the sun which is capable of conveying a message about commercial origin. So it may have a meaning and still be not, and still be distinguishable from B. And I don't believe, actually, the point that you make, that it's necessarily so that, as it is enlisted also in Article 7, it must also be tested as against the goods or services. It refers back to...
Tell me why you don't believe that, because the legislation in Article 7 and 59 explicitly applies to all of the grounds of objection. So in theory, no, in reality, if I make an application for a single good, a single description of good, why shouldn't it be examined by reference to the goods, both for the purposes of A and B? I don't understand why not.
So I understand A as just referring back to the definition of
I know,
eligible
that's
for
the boundary
and
I'm
that's
pushing, because I think
Right,
it's wrong.
I think at this point we
Okay.
need to give
Yeah.
our audience an opportunity for another question.
Yeah.
Who wants to go next? Stunned silence. Yes, Artie.
Hi there. This is a question for Geoffrey, although Richard, I'd be also interested in your views. And it's perhaps not as learned as the discussion we've just had, but can you tell us what your top 3 most influential cases that have been decided under the 94 Act would be? They can't all be yours.
You mean domestic decisions rather than Court of Justice?
Yes, UK decisions.
There's no pure domestic decisions, because they're all, as it were, impregnated with CJEU jurisprudence. You know what? I'm struggling. Give me some clues. Do you play charades? Can you?
There's no right or wrong answer. I was just interested, looking, having looked back at...
I'll send you an email later. Nothing occurs to me. There are some decisions which went... How do you read a decision? I don't know whether I'm typical or not. I've reached the point, don't ask me when I reached it, when I read a decision and I just go through it and I think, do I agree with that or don't I agree with that? If I finish reading the decision and I think, oh, I agree with that, I kind of forget about it because I think, oh, well, I already knew that. It didn't tell me anything I didn't know. Whereas if I find something in there that gets the hairs up on the back of my neck, to me, that's a very memorable decision and I don't forget it too easily. But that's kind of like how you read at speed into these cases. Richard, can you answer that question? And
Well,
you're not allowed to give any of yours.
No,
They can't all be yours.
The problem with it is that, for me, it's always the last one that I was working on. So at the moment, my mind is full of the case that was argued in front of me yesterday, which is, believe it or not, all about comparison of services. When are services similar? And it's a second appeal starting in the registry. And so sloshing around in my mind is, of course, trees, for sure, canon, but also some of the subsequent case law in that area. Struggling with what we mean by complementary. Anybody in the room had to deal with that? I'm sure some of you have. Yeah.
Well, then let me pick up on that then. As an abstract question, not designed to influence the thinking of the Court of Appeal in any way, shape or form. What do we mean by similar? If I make a statement that everybody in this room is similar to everybody else in this room, it can be true. If I make a statement that everybody in this room is not similar to anybody else in the room, it can be true. And why? Answer, because it depends on the criterion or criteria I'm using to make the comparison. And half the trouble with all the case law on similarity and what's not similar and so on and so forth is that they're never clear about the criteria they're actually using. That's why you get into complementarity and all the stuff that goes with it that makes it worse.
Oh, I think that depends on... there are, for instance, to quote something that Alexander von Mühlendahl said this afternoon, if you look at other jurisdictions, maybe you find more I think we got more than enough criteria to adjudicate on or to assess similarity between signs. A lot of things.
We have.
Yeah.
So are air conditioners and refrigerators similar?
Yes, well, on that subject, I'll take the question in a moment. But since I've been plugging academic works this evening, I'll plug another one. For those of you who haven't read it, there is a wonderful book called The Confusion Test in European Trademark Law, authored by Ilana Fima of this institution and Dev Ganji of Oxford. And one of the advantages of that book is that the authors did a very thorough job of analysing not just the domestic case law on likelihood of confusion, but also all of the then extant case law of the General Court, and the book was published in 2019, and even then there was a lot of them. And so if you want a detailed treatment of the question of similarity of goods and services, that's the place to go to, because you will find Chapter 6 analyses all of that case law in a very helpful way. So go have a look at that if you have a problem. So, over here, Roland.
You've now given rise to a second question, because my second question is, Ilana, when are you going to bring out the second edition of that, please? I look forward to it. So my question was directed at all of those who have a memory of the 1938 Act. Was it all a breath of fresh air? Is there any of it you would like to have kept?
Me, I never want to turn back to the 1938 Act.
I miss it greatly. Section 4?
I rest my case again. What?
Section 4.
What was so good about that?
Was it not... I have a recollection.
Microphone. So,
I have a recollection, and you'll correct me if I'm wrong, Robin. Was it at your swearing in as a member of the IP bench that you were begged to have no impact whatsoever on Section 4 because that was what was keeping the IP bar going?
That was Anthony Walton.
Yes, that's right. I can answer it.
Here we go. There we go.
No, he begged me not to decide what a trademark was. That's what he actually said. He said this had keep lawyers going for generations, and would pay for the school fees and the grandchildren's school fees and so on and so forth. And whatever I should do, I should never decide what a trademark was. And I think it's fair to say, in my opinion at least, that we're less clear what a trademark is now than we were then. And it was a right old mess then.
Yeah.
So you don't want to go back to it, you want to improve where we've got to.
Well, I
You
think some of the
can't want to
concept...
turn the clock back to that.
No, Section 4 was or phylogenious obscurity fame. Is,
So they said.
I mean, it prevented comparative advertising.
Anthony Walton's actual words, as I remember, because I was sitting about 2 rows behind him, were, "Now is your chance, my lord, to sort out the mysteries and the difficulties surrounding Section 41B of the Trademarks Act. For God's sake, don't do it."
That's
Right. Another question. Yes.
Hello. I had a question for the rest of the panel after Robert's comments on potential divergence from the EU. I understood from Robert's comments that he sort of sees Brexit potentially as offering an opportunity to move away from case law that maybe we don't like on free riding and things like that. But on the grounds that I think you were suggesting, Robert, of moving away from Court of Justice jurisprudence, I'm not sure I totally agreed with them. On the first ground, you said that they sort of have a very different mode of legislative interpretation. But I think the UK courts now apply sort of purpose of interpretation statute. I was reading UK statute recently that had a sort of objectives provision, which is very similar to a recital, which I think you were saying is different, a point of difference. And also you talked about different policy goals of the Court of Justice compared to us. But we exist in a trading union with the EU, and obviously there's trade gravity, so there's an interest in traders being able to sort of understand the rules of the road in the UK and the EU in a similar way. So sort of with that little mini critique, I wanted to get...
No, I mean, that was my question. I mean, do we care? I mean, I think that's...
Yeah, well, I mean, what this brings back to is where we started this panel with. It's 30 years of the Trademarks Act 1994. Part of the purpose of the Trademarks Act 1994 was simply modernising our own domestic legislation because, as we've just discussed, the 1938 Act was not a good piece of legislation, whichever way up you held it. But a key purpose, of course, was harmonisation with what is now EU law. And now that we've left the EU, obviously, the question arises to what extent the United Kingdom should continue to follow EU trademark law and to what extent it should chart its own course. And perhaps go back more towards looking at other Commonwealth sources of law for inspiration instead. And that is quite a big question. One of the questions it raises is, well, what is the purpose of harmonisation? Why do we want harmonisation? And of course, harmonisation is something that is very much the fore if one's in the EU context, but it doesn't just apply in the EU context. I mean, we have international conventions to harmonise trademark law and indeed other laws as well, of course. And one has to ask oneself, well, to what purpose is served by having independent development of trademark law? Now, it's open, of course, to the UK legislature to decide to make different policy choices and to implement those different policy choices in legislation, but thus far it hasn't done so. In the absence of legislative change, to what extent should the courts go in a different direction? And of course on that, we are subject to certain constraints. We have the constraints in the 2018 Withdrawal Act as modified by the 2020 Withdrawal Act, and now the Ruler Act, Section 6 of which is not in force yet. So we have certain constraints, but also certain freedoms. To what extent should we use those freedoms? So, Robert, another word from you on that.
I think cautiously. I mean, but there are some bits of EU trademark law that we would be well to jettison, I think, as soon as possible.
And you would say the policy goals, the policy gains to be achieved by that outweigh the advantages of harmonisation.
Yeah, I think I would say that. I think if you take L'Oreal and Below as an economically, as a decision that makes no sense in economic terms, then absolutely that's one we should get rid of.
Even though there's a cost to traders who are trying to trade across borders.
Yeah, I mean that is the question. But I suppose the issue for the courts is going to be to what extent do we focus on developing our own trademark law that is as good as it can be for people operating in the UK versus continuing to stick as close as we can to the European family. But I think recognising that is itself a time-limited goal. I think I just cannot see you being persuaded to go down the same, over time I think that the influence of the CJU will inevitably wane.
Annette.
May I say something? Again, I said it already, L'Oréal Vibeleur was badly decided, definitely, but you don't have to get rid completely of what the court said in that decision, because you could also interpret it in a manner that makes sense. Or at least you don't have to get rid of the part of EU law that they were trying to interpret in that decision, let me put it that way. Because, at least insofar as trademark law is concerned, because regarding the part on extended protection, they simply omitted looking into due cause, and this is something that I also wanted to say in the afternoon, but we didn't have so much time. Geoffrey, you said that there is no way to distinguish between unfair taking advantage and due cause. I think there is a certain way to distinguish, but there is a lot of overlap, that's true. But I would say there is a certain distinction between the two, because the taking of advantage asks how a trademark is used. The question of due cause asks why the trademark is used by the competitor. And the Court of Justice definitely omitted that part, asking why was that done, and if they had realized that there was a purpose behind it, namely to inform the public about the properties of the goods, namely that there were smell-alikes, they might have been more cautious, or at least nobody is hindered in applying what the law that was interpreted in L'Oréal v. Berleur, but interpreted differently. So that would be my first point. The second point would be about the functions theory, and I think we have already said that the functions theory may work quite well, but that, of course, another thing, the bad part about L'Oréal Velour is not so much what the court said about trademark law, but it is in the directive on comparative advertisement that basically prohibits comparing trademark goods, and that is the dangerous part, and that should not be taken over. But that then, that's my last point. The question that was posed is another one. So again, trademark law, I think, can be interpreted in a good way, even if the rules are kept. But what is the more difficult part is unfair competition. And you said it yourself, that trademark law has taken in a large part of what was previously unfair competition. And the question is, do you want to keep that? And if not, what do you do instead? Because there is no unfair competition law, as far as I know,
Not as such.
apart from passing off. And that is the part, I think, that...
Well, that takes us back to Kelly's presentation. So does Annetta's way of looking at unfair advantage and due cause have any resonance for you? Do you have any concern arising out of the fact that we don't have a law of unfair competition in this jurisdiction?
It definitely feels like there's a gap there at the moment, and there's something that needs to change to address it. So I would say yes, I'm in favour.
Right. So we're almost out of time, but does anybody in the room have one last burning question? Yes, over here, and then we will break for drinks. So make it a short one if you can, please.
Thanks very much. Just on this is a reflection on the last 30 years. Just wonder what the panel thought about the appointed person system over the last 30 years. It was a big change, and just thoughts, general thoughts, pros and cons.
Well, that's a really good question, and I will ask someone who's been doing it all that time. Geoffrey, what do you think?
It's a magnificent. Look at the advantages of it. You've got a knowledgeable tribunal. It's cheap to lose in that tribunal, and you can't appeal unless it's within the scope of judicial review. So basically, the tribunal would have to bite someone in the leg or do something really serious in order to abort the hearing. And those values are highly appreciated by all the litigants that have been involved in appeals. In cases in the registry. So when it comes to appeals, the statistic has been consistently that it's 70% or more that go to the appointed persons.
Currently more, I think.
Is it more?
Yeah.
Very cost sensitive at the moment, I should think. So it filled a need, and David Llewellyn in Singapore has become, I don't think they use the expression appointed person, but he occupies that role in Singapore. And it was, if you want to know, it was two people. It was Mike Knight and Norman Harkness in the registry who, in the last knockings of the legislation going through Parliament, decided that they needed something which was like what they used to call the delegate of the Board of Trade under the 1938 Act, a nominated barrister usually. They wanted something better, more modern and more comprehensive. And in the last knockings, they just adopted the appointed person system. I personally, you tell me, I personally think the system has worked really very well.
Good. Well, on that note, let us adjourn and thank our speakers, and there are drinks outside.